Welcome to the Elder Law channel, and today's question is, how is property transferred at death? Well, property can transfer in a number of different ways upon death. First of all, let's talk about probate property. Probate property is any property that's owned by the person at the time of their death and that does not automatically pass by operation of law to somebody else, such as beneficiary designation or a survivorship feature, which we'll talk about. If someone has a last will and testament, that will control the distribution of the decedent's probate property. If somebody dies without a valid last will and testament, the property in their probate estate will pass under the intestate succession law of the state in which they live. And we've had another elder law talk on that topic. So if you haven't seen that, look that one up. The next way that property can pass is by a beneficiary designation. Property where someone designates a beneficiary will pass automatically to that beneficiary if they're living. It doesn't matter what their last will and testament says. So the beneficiary designation trumps their last will and testament. That designation is a contract. It supersedes their will. Beneficiary designations are common with life insurance and retirement plans, but they could be added to almost any other type of asset, such as a bank account or an investment account. And depending upon the person's estate plan, the beneficiary could be a spouse, or it could be children, or it could be some other beneficiary. Another way that assets pass is by joint ownership with right of survivorship. So when two or more people own property jointly with right of survivorship, the result is that when one of those people pass away, the property will pass automatically to the surviving joint owner or owners, regardless of what their will may say. That's a common way for spouses to own bank accounts or real estate together. Adding somebody as a joint owner on a bank account or an investment account for convenience purposes could, however, have unintended consequences, and it's not really recommended. A trust is yet another way that property can pass at death. Property can be owned by a trust at death, or it can pass to a trust at death by way of a will or a beneficiary designation. Property that is owned by a trust at death is excluded from the person's probate estate, and the trust's terms will control who gets the property and how that property passes to them. And trusts can be set up for a number of different benefits, whether it's a tax benefit or a non-tax benefit. So an estate plan is much more than just the last will and testament or a trust. It's very important to coordinate the titling of assets with the overall estate plan. So that's today's Elder Law Talk. Thanks for joining us, and we'll see you next time.